Feiner v. New York, 340 U.S. 315, 1951. Mr. Chief Justice Vinson delivered the opinion of the court. Petitioner was convicted of the offense of disorderly conduct. On the evening of March 8, 1949, Petitioner was addressing a street corner meeting in the city of Syracuse. The police received a telephone complaint concerning the meeting, and 2 officers were detailed to investigate. They found a crowd of about 75 or 80 people, both Negro and white, filling the sidewalk and spreading out into the street. Petitioner, standing on a large wooden box on the sidewalk, was addressing the crowd through a loudspeaker system attached to an automobile. Although the purpose of his speech was to urge his listeners to attend a meeting to be held that night in the Syracuse Hotel, in its course he was making derogatory remarks concerning President Truman, the American Legion, the mayor of Syracuse, and other local political officials. Feiner referred to Truman as a bum, to the mayor as a champagne sipping bum who does not speak for the Negro people, and to the American Legion as a Nazi Gestapo. The police officers made no effort to interfere with Petitioner's speech, but were first concerned with the effect of the crowd on both pedestrian and vehicular traffic. The crowd was restless, and there was some pushing, shoving, and milling around. At this time, the petitioner was speaking in a loud, high-pitched voice. He gave the impression that he was endeavoring to arouse the Negro people against the whites, urging that they rise up in arms and fight for equal rights. The statements before such a mixed audience stirred up a little excitement. Some of the onlookers made remarks to the police about their inability to handle the crowd, and at least one threatened violence if the police did not act. There were others who appeared to be favoring Petitioner's arguments. Because of the feeling that existed in the crowd both for and against the speaker, the officers finally stepped in to prevent it from resulting in a fight. One of the officers approached the petitioner, not for the purpose of arresting him, but to get him to break up the crowd. He asked Petitioner to get down off the box, but the latter refused to accede to his request and continued talking. The officer waited for a minute and then demanded that he cease talking. Although the officer had thus twice requested Petitioner to stop over the course of several minutes, Petitioner not only ignored him but continued talking. During all this time, the crowd was pressing closer around Petitioner and the officer. Finally, the officer told Petitioner he was under arrest and ordered him to get down off the box, reaching up to grab him. Petitioner stepped down, announcing over the microphone that the law has arrived and I suppose they will take over now. In all, the officer had asked the petitioner to get down from the box 3 times over a space of 4 or 5 minutes. Petitioner had been speaking for over a half hour. On these facts, Petitioner was specifically charged with violation of Section 722 of the Penal Law of New York, the pertinent part of which is set out in the margin, footnote 1. Section 722. Any person who with intent to provoke a breach of the peace, or whereby a breach of the peace may be occasioned, commits any of the following acts shall be deemed to have committed the offense of disorderly conduct. 1. Uses offensive, disorderly, threatening, abusive, or insulting language, conduct, or behavior. 2. Acts in such a manner as to annoy, disturb, interfere with, obstruct, or be offensive to others. 3. Congregates with others on a public street and refuses to move on when ordered by the police. We are not faced here with blind condonation by a state court of arbitrary police action. The courts below recognized petitioner's right to hold a street meeting at this locality, to make use of loud-speaking equipment in giving his speech, and to make derogatory remarks concerning public officials and the American Legion. They found that the officers in making the arrest were motivated solely by a proper concern for the preservation of order and protection of the general welfare, and that there was no evidence which could lend color to a claim that the acts of the police were a cover for suppression of petitioner's views and opinions. Petitioner was thus neither arrested nor convicted for the making or the content of his speech. Rather, it was the reaction which it actually engendered. The language of Cantwell is appropriate here. Where clear and present danger of riot, disorder, interference with traffic upon the public streets, or other immediate threat to public safety, peace, or order appears, the power of the state to prevent or punish is obvious. We are well aware that the ordinary murmurings and objections of a hostile audience cannot be allowed to silence a speaker, and also mindful of the possible danger of giving overzealous police officials complete discretion to break up otherwise lawful public meetings. But we are not faced here with such a situation. It is one thing to say that the police cannot be used as an instrument for the suppression of unpopular views, and another to say that when, as here, the speaker passes the bounds of argument or persuasion and undertakes incitement to riot, they are powerless to prevent a breach of the peace. Affirmed. A concurring opinion of Justice Frankfurter and a dissenting opinion of Justice Douglas, in which Justice Minton concurred, are omitted. Mr. Justice Black dissenting. The record before us convinces me that petitioner, a young college student, has been sentenced to the penitentiary for the unpopular views he expressed on matters of public interest while lawfully making a street corner speech. The court's opinion apparently rests on this reasoning. The policeman, under the circumstances detailed, could reasonably conclude that serious fighting or even riot was imminent. Therefore, he could stop petitioner's speech to prevent a breach of peace. Accordingly, it was disorderly conduct for petitioner to continue speaking in disobedience of the officer's request. As to the existence of a dangerous situation on the street corner, it seems far-fetched to suggest that the facts show any imminent threat of riot or uncontrollable disorder. It is neither unusual nor unexpected that some people at public street meetings mutter, mill about, push, shove, or disagree, even violently, with the speaker. Indeed, it is rare where controversial topics are discussed that an outdoor crowd does not do some or all of these things. Nor does one isolated threat to assault the speaker forebode disorder, especially should the danger be discounted where, as here, the person threatening was a man whose wife and two small children accompanied him and who, so far as the record shows, was never close enough to petitioner to carry out the threat. Moreover, assuming that the facts did indicate a critical situation, I reject the implication of the court's opinion that the police had no obligation to protect petitioner's constitutional right to talk. The police, of course, have power to prevent breaches of the peace. But if, in the name of preserving order, they ever can interfere with a lawful public speaker, they first must make all reasonable efforts to protect him. Here the policeman did not even pretend to try to protect petitioner. According to the officer's testimony, the crowd was restless, but there is no showing of any attempt to quiet it. Pedestrians were forced to walk into the street, but there was no effort to clear a path on the sidewalk. One person threatened to assault petitioner, but the officers did nothing to discourage this when even a word might have sufficed. Their duty was to protect petitioner's right to talk, even to the extent of arresting the man who threatened to interfere. Instead, they shirked the duty and acted only to suppress the right to speak. Finally, I cannot agree with the court's statement that petitioner's disregard of the policeman's unexplained request amounted to such deliberate defiance as would justify an arrest or conviction for disorderly conduct. On the contrary, I think that the policeman's action was a deliberate defiance of ordinary official duty, as well as of the constitutional right of free speech. For at least where time allows, courtesy and explanation of commands are basic elements of good official conduct in a democratic society. Here, petitioner was asked, then told, then commanded to stop speaking. But a man making a lawful address is certainly not required to be silent merely because an officer directs it. Petitioner was entitled to know why he should cease doing a lawful act. Not once was he told, I understand that people in authoritarian countries must obey arbitrary orders. I had hoped that there was no such duty in the United States.